Hello everyone, Green Card. Welcome back to our channel, U.S. Immigration. We hope you're doing great. In this video, we're going to talk about urgent notice from Trump to Green Card holders. Your status depends on this step. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. The American public is reeling, but no group feels the shock more intensely than immigrants with lawful status, especially permanent residents. The federal government's latest announcement has sent tremors across the nation, leaving millions of green card holders wondering whether the stability they once trusted has suddenly vanished. The president's message is clear. Permanent residency will no longer be a passive privilege. New conditions, new scrutiny, and new risks now define the landscape. A direct order from the president. New rules for green card holders. President Donald Trump has issued a sweeping directive to federal agencies, instructing them to adjust immigration rules in a way that directly affects all permanent residents. Under this proposed framework, only those who satisfy new federal conditions will be able to keep their green card. In essence, lawful permanent residency, once considered a secure foothold in America, may now be subject to active review, reevaluation, and possible revocation. This marks a dramatic escalation in the administration's approach to immigration and has stunned millions who believe their legal status insulated them from policy shifts aimed primarily at undocumented individuals. A new target, those who follow the rules. For years, President Trump framed immigration enforcement around individuals with criminal records or those lacking legal status. His campaign speeches repeatedly emphasized targeting criminal aliens and undocumented populations. But recent developments have taken an unexpected turn. Reports from across the country now highlight rising cases of lawful immigrants, people with valid documentation, long histories in the U.S., and clean records being detained, placed in removal proceedings, and even deported, according to federal statements released nationwide. The administration views this as a necessary expansion of enforcement authority. A controversial claim, the Attorney General's power to revoke residency. The most alarming development came when the Department of Justice notified the Third Circuit Court of Appeals that U.S. Attorney General Pam Bondi holds full authority to review and potentially revoke a person's permanent residence at any time and for any reason. This announcement, delivered formally to the courts, signals that the federal government believes it can unilaterally strip green card holders of their status without showing cause. Unsurprisingly, this has generated enormous uncertainty among immigrants who followed every legal step, passed every background check, and built their lives around the promise of lawful residency. Courtroom showdown. Could green cards be revoked years later? If the Third Circuit aligns itself with the administration's position, the government would gain the ability to revoke green cards long after they were issued, even decades later. Critics argue that such power would undermine due process, destabilize immigrant communities, and open the door to arbitrary enforcement. During the recent hearing, the DOJ insisted the Attorney General's authority is broad and unrestricted, allowing status revocation without limitations. Should the court adopt this interpretation, millions of permanent residents would live under perpetual risk of detention, arrest, or deportation, regardless of their compliance with U.S. immigration law. Legal experts sounded alarm. Immigration scholars, including Pace University law professor Elizabeth Hull, emphasize that the Immigration and Nationality Act does not permit DHS or the Attorney General to revoke permanent residency unilaterally. Green card holders possess a legal right to appear before a judge, present their case, and receive proper due process. This long-standing protection is now being tested. If the courts ultimately uphold the administration's interpretation, the decision would fundamentally reshape the rights and security of lawful permanent residents nationwide. A reinterpretation, not a new law, but with massive consequences. Importantly, this proposal is not new legislation. Instead, it is a reinterpretation of existing law, one that dramatically expands federal authority over lawful immigrants. The administration now asserts it can redefine the obligations, rights, and even the permanence of permanent residency itself. For millions who fought hard to obtain their green card, this moment introduces an unsettling question. How permanent is permanent residency now? AG Pam Bondi has the power to revoke green cards at any time, Justice Department claims. The Justice Department has suggested that Attorney General Pam Bondi has the authority to revoke green cards as she sees fit. DOJ Attorney Lindsay Murphy posited Bondi's alleged power during a Third Circuit hearing in Philadelphia. If the court side with the Trump administration's position, it could jeopardize the lawful residency status of the U.S.'s estimated 12.8 million green card holders. Murphy suggested that the Attorney General has full discretion to revoke the permits at any time for any reason, even for legal permanent residents who had lived in the U.S. for decades. People with green cards can live and work in the U.S., receive Social Security, Medicare, and financial aid for college, and serve in the military. It comes as Donald Trump continues to ramp up his immigration crackdown, pledging to deport millions of migrants who don't have the right documentation and fueling concerns for those who do. The president has ordered DHS Secretary Kristi Noem to add 20,000 officers to enforce his deportation policies, and her agency is reportedly considering a TV show that would see migrants competing for citizenship and offering $1,000 incentives to immigrants who self-deport. Murphy made her argument during Tuesday's hearing, according to Newsweek, which focused on an ongoing case involving Mohammed Kadhanani, the Palestinian-born imam who has lived in New Jersey since 1996. Kadhanani has been seeking permanent residency in the U.S. and fought off deportation for decades amid government accusations that he is linked to the Palestinian terrorist organization Hamas, which he denies. He was granted permanent residency in 2008 after an immigration judge ruled against his deportation, which the government appealed. The immigration judge ruled in favor of Kadhanani in 2020, but a year later, the Board of Immigration Appeals, which sits within the DOJ's Executive Office for Immigration Review, reversed the ruling through initiating certification, ultimately rescinding the religious leader's green card. Murphy was pressed on whether there was a time frame for certification, with U.S. Circuit Judge Ariana Freeman asking, "Do you mean even 10, 20 years later?" The regulation doesn't impose any time limit, so yes, Murphy added, before adding that it would require exceptional circumstances. Probed on what qualifies as an exceptional circumstance, Murphy told the panel that the Attorney General has full authority to make that determination. "That's an extraordinary position for the government to be taking, don't you think?" Freeman added.